It was not the first statement on the rights of Canadians, but it has surely become the most definitive. Enumerated in just 34 concise sections, Canada's Charter of Rights and Freedoms opened the door to momentous legal change that rippled well beyond the courts and legislatures of this land. It even added to our public lexicon such iconic phrases as the notwithstanding clause, and for you super geeks, demonstrably justified in a free and democratic society. Joining us now to reflect on 35 years of the Charter, we welcome Peter Hogg, Professor Emeritus, Osgoode Hall Law School; Alex Neve, Secretary General, Amnesty International Canada; Vanessa McDonnell, Law Professor, University of Ottawa; Dennis Baker, Professor of Political Science, University of Guelph; and Catherine Hensel, lawyer and principal with Hensel Barristers, representing Indigenous organizations and First Nations and their members. And we are delighted on this important anniversary in our country to welcome you five around our table here for a conversation about how we protect civil rights in this country now. And Peter Hogg, I'm coming to you first. There may be a sense in the country that before the Charter, there was no protection of our civil rights. Was that actually the case?
No, that was not the case. The common law did protect a lot of rights, but what it didn't do is stop Parliament or the legislatures from changing them. The Charter does that.
What's the most significant change, in your view, in a post-Charter Canada?
I think the change really is the shift from the Parliament to the judiciary. The rights that Peter was talking about pre-1982, this Parliament was seen as the guarantor of those rights, and that really has diminished. When I say that to students these days, they're astonished that that was ever the case. They see the legislature as the rights-infringing monster that has to be held back by the court.
You don't quite share that view, do you?
I don't.
No. We'll probably get into a little bit of that. Let's just go back to the day, shall we? This is a picture on the 17th of April, 1982. It's a well-known shot. There's Queen Elizabeth II signing the royal proclamation. The current Prime Minister's father on the left, yes, he was the Prime Minister of the day, different Prime Minister Trudeau for our younger viewers, and Andre Ouellette, Jerry Regan, Michael Pitfield, Michael Kirby, in the background, everybody watching. Here's what was signed. We now have freedom of expression, including the media, enumerated in this Charter of Rights and Freedoms. The right to a democratic government, the right to live and seek employment anywhere in Canada, legal rights of persons accused of crimes, Aboriginal people's rights, the right to equality, official language rights, the protection of Canada's multicultural heritage. That's all there. Now, there were, I don't want to go back to too much of the negotiations here, but there were three First Ministers essentially in it from the beginning. Pierre Trudeau, Bill Davis of Ontario, Richard Hatfield of New Brunswick, who all believed that the Charter was essential to improving our rights. Why did they feel that way?
Well, I think if you look at least Pierre Trudeau's perspective, one of the things that was motivating him over a fairly lengthy period in terms of trying to propel this Charter forward was the idea that a Charter of Rights and Freedoms might help to heal some of the divisions that existed between Quebec and the rest of Canada. The idea being if there was a single set of rights that all Canadians could get behind, that this might have a unifying effect on Canada. And that was something that Trudeau believed very strongly.
What about the potential unifying effect between Canadians and their Indigenous cousins?
That wasn't, I don't think, expressly contemplated, except through Section 25, which is more of a shield than a sword. So is Section 35, where Aboriginal and treaty rights are recognized and affirmed, but that's outside of the Charter. Those are collective rights. And again, that is a shielding provision as opposed to a positive, it doesn't accord positive rights, just recognizes and affirms rights that should exist prior to 1982.
Well, do you think our rights are better protected under a post-Charter world than they were before?
Oh, there's no question. Absolutely.
That's beyond debate.
I think absolutely. The kinds of victories we've seen in rights protection over these 35 years speaks to that. Now, part of that is society is evolving, and some of those rights issues would have come of age anyway and would have been protected through other means. But I think going back to Peter's point about, what was so innovative about this was the courts truly having the power to be the ones who would stand up often for marginalized, disenfranchised groups who don't have the same access to justice or the avenues of power that would have led to that change. And the Charter was a real game changer.
As you look back at 3.5 decades of post-Charter jurisprudence, what's the blockbuster decision that you look at and say, this is new, this is different, this would not have happened in a pre-charter world?
Well, you might pick the physician-assisted dying case, which is just a very recent case, but it had never been accepted clearly as a right before the decision. And the case was taken by a very skillful lawyer called Joe Ave, and Joe persuaded the court that the Charter, Section 7, which protects life, liberty, and security of the person, gave the right to physician-assisted dying for somebody who was in desperate pain and wanted to die. And that was completely new.
Seems unlikely that kind of judgment would have been made before the Charter.
No, it would not have been.
It would not have been.
It wasn't even made while the Charter was in place. So in 1993, the court had that issue before them and upheld those very same laws they struck down in 2015. So I'm always careful about saying the Charter did this and the Charter did that. It seems to me it's more about what the current judicial preference is more than what the Charter demands. So I just want to make that quick
Okay,
point.
fair point. Have you got a sort of blockbuster on your list of important decisions?
There are certainly lots of them. One that you see scholars consistently refer to is the Stinchcombe decision. And this was a decision in which the Supreme Court concluded that accused persons have a constitutional right to disclosure. And what this means essentially is they have a right to know what evidence the Crown intends to rely on in the prosecution. And it's now difficult to imagine a world in which an accused person would go to trial without knowing what evidence the Crown had in its possession. But until Stinchcombe, this was not a constitutional requirement. It was a decision that has had a very positive impact for accused people. It also had huge resource implications. So Crown's offices across the country were required to hire staff to accommodate this huge new obligation, much the way we see now with the Supreme Court's recent decision in Jordan on the right to trial within a reasonable time.
And apropos of Professor Baker's previous comment, would that decision, I mean, does the Charter get the credit for that decision, or is just these judges?
No, I think the credit is absolutely owed to the Charter.
We in this country appear to have found the sweet spot as you look around the world. Right before we had the Charter, we had sort of the supremacy of Parliament making laws and deciding what your rights were going to be. In the United States, the Supreme Court is the ultimate arbiter down there. We've got a bit of a different situation, a classic Canadian compromise. Sheldon, let's bring this up if we can, because there are, of course, limits on our rights in this country. Section 1 of the Charter says that governments may limit Charter rights so long as those limits are ones that a free and democratic society would accept as reasonable, whatever that means. And of course, the other one that we all know, the notwithstanding clause, lets governments pass laws that may violate the Charter. They must clearly state to the public that they are doing so, and they must review and reenact the Declaration every 5 years. The federal Parliament, I don't believe, has ever used this power of the notwithstanding clause. A couple of provinces and one territory have, Quebec and Saskatchewan being the two provinces and Yukon being the territory. I guess I want to understand, why have the feds never used the notwithstanding clause, even though it's been there for 3.5 decades?
Well, I think interestingly, Steve, that when the notwithstanding clause was originally proposed, it's sometimes seen as guarding provincial rights. It was the provincial premiers that really pressed for it. But as my friend Ted Morton always likes to point out, the federal government didn't have to give it to themselves, right? John Chrétien and Pierre Trudeau decided the federal government should have this power too, which I think speaks to its legitimacy. Now, as I think everyone on this panel knows, it got intimately tied up with Quebec separation. So the Quebec National Assembly was the one that really used the Omnibus Act. They were upset by the Quebec government was upset by not being included in the charter-making process, so they declared all Quebec laws to be operating notwithstanding the Charter, which was a bit of a signal to the rest of the country.
Peter Hogg, are you, as a legal scholar, are you comfortable with the fact that our rights are adequately protected, even though we have this out clause, if you like, saying Parliament can override any Supreme Court decisions if they don't like them?
No, I think it's a very, very wise Canadian compromise. And what happened in Quebec, and Quebec has used it as well to protect language rights. I think having a safeguard of that kind for the case where a democratic body feels that an issue is so important that it has to override the Charter of Rights. I think that's a good outlet to have, and it's been very rarely used.
Yeah, can you speak to the politics of that? Because it has been, it's a very odd or rare case when it has been used. Why do you think that is?
Well, one likes to think it's because there's no appetite to do so, that even though it comes up every once in a while, we're seeing it come up as a proposition in the Conservative leadership race right now with respect to refugee claimants coming from the United States, for instance. But fortunately, I don't think we ever see that it gets a lot of traction, and I think most politicians from any party recognize that it wouldn't be an overly popular thing to do, that Canadians have pride in the Charter, and that you would really have to make a very extreme case. It's not in keeping with what our international human rights obligations are, where there's much more specific restrictions on when a government can abrogate its human rights responsibilities. The Charter does go further than that, so we would be out of line with what the UN says we could be doing. And let's hope that continues to be the case.
Does it seem to you that the optics of any government trying to abrogate charter freedoms is just a mountain too high to climb for most governments in this country?
I think not necessarily in our experience with respect to Indigenous people. We regularly find across the board that are a wide variety of liberty-related and other rights, because they are systemically infringed upon and collectively held. We get very little traction both within the Charter and legislatively, so there's less of a prospective check on government power through the Charter, and we quite regularly find that our collective rights and our individual, therefore, well-being and welfare is really trampled upon by legislative initiatives or failure to correct legislative statutes and other government acts that really have devastating impacts within our communities and families.
Do you think that Indigenous people in Canada ought to or ought not to be covered by the Charter?
Well, they are in the same way that all Canadians are covered. Unfortunately, that fails to prevent the harm that I've talked about. During the last 35 years, over-incarceration has actually gravely increased. Our experience while in custody has worsened. Children are more overrepresented in the child welfare system. The safety of our girls and women is further compromised, I think, it's safe to say, than it was 35 years ago.
So the Charter has not helped Indigenous Canadians as much as you might have hoped? Or
I
at
would
all?
say it's close to not at all.
Close to not at all.
Close to not at all. And the Charter, a lot of the rights in it are focused within the criminal justice process. Our engagement is with that is largely at the guilty plea stage or at bail, sentencing. The Charter hasn't had, therefore, the same traction in the lives of people who have contact with the state or collectively or individually have infringement on their life, liberty, well-being by state actions.
If that's the case, Professor McDonnell, let's look at the other side of the coin. Who has it helped the most?
Well, in some ways, I think it's difficult to point to one particular group that has experienced sustained success in the court. So there are groups who have been quite successful. I would say there are some organizations, LEAF, the Legal Education and Action Fund, which promotes women's issues, the Canadian Civil Liberties Association, Amnesty. There are organizations that have had some really big wins in the courts, and they've become quite good at what we call impact litigation, right? In advancing a progressive agenda through the courts. But I would say a lot of these groups would look at the last 35 years and say, we can point to almost as many losses as wins. And so I think that the record is mixed. And scholars increasingly, I think, are saying, let's not be too quick to say that the Charter has been a complete success. If you look at many groups, they are not necessarily better off than they were before the Charter.
And I think there's a really important follow-up piece there, that this is also about access to justice. You know, the Charter is there and has great promise, including, as Catherine's highlighting, you know, all those provisions apply to all of those Indigenous rights concerns that she's so rightly highlighted. But in order to advance Charter challenges and Charter claims, it's costly, it takes time. We have at various times had government assistance in place through what's been known as the Court Challenges Program.
You would acknowledge Stephen Harper took that away, but Justin Trudeau is bringing that back.
It's just coming back now. But so you can't, I think, analyze the question of who the charter benefits without also considering this issue of who has access to the kind of justice that can actually see charter challenges go ahead.
I do want to follow up, though, on a comment you make and put this to Professor Baker, because back in the day, we're going back 35 years now, a number of the premiers didn't like the idea of a charter because they didn't like the idea of giving up rights to judges who were appointed essentially for life, retirement at 75, but they felt the loss of their power and a transfer of power to judiciaries, and they were very uncomfortable with that. What does the record over the last 35 tell us about whether or not they ought to have been concerned about that?
I think Peter Russell, at the dawn of the Charter, warned about the legalization of politics, the judicialization of politics, where we would take reasonable disagreements that we would expect Parliament to work out, sometimes messy compromises, would now be transferred to a judiciary that would solve them once and for all. And we've seen, as we discussed earlier with the assisted suicide case, it doesn't resolve them once and for all. They come back again because they often reflect these deeply held and contested values.
Well, let me go back at you.
Okay.
I mean, abortion kind of got solved once and for all as a result of the court saying the abortion law in this country is illegal.
It did not declare a substantive right to abortion. It actually had procedural requirements that Parliament could have responded with.
But they chose not to.
They chose
In
not
other words,
to.
the Parliament.
I don't know if they chose
the
not to.
Parliament
They
took the ball and ran with it.
They failed to pass law.
You might,
The law failed on a tie vote in the Senate and was never brought back.
Could you put same-sex marriage in that same category, whereby the courts made a decision and legislatures were all too happy to wipe their hands of the politics with it and said, sorry, we can't do anything about it, the Charter has spoken?
Yes, I think you could. A lot was done by the courts, but you know, the last thing that happened was enacted by Parliament, and that was the Same-Sex Marriage Act, which clearly changed, the Parliament changed the definition of marriage so that no longer required people of different sexes. So there was something of both there, but up until the Parliamentary Act, the courts had struck down a lot of discrimination against same-sex unions, and so that was just the culmination of. But it was
the Supreme Court itself never said that the opposite sex definition of marriage was unconstitutional. That was left open in the reference case, and then Parliament finished the dialogue.
Well, I guess the example I'm thinking of came about 20 years ago when Mike Harris was in power in Ontario, and the courts came down with a decision about same-sex benefits, I think it was, and he said, okay, we're in line. Now, you know his social conservative base wasn't happy with that, but he basically said that judges have spoken, the Charter has spoken, let's move along. And they redrafted, I think, 67 laws in order to comply with this new decision. I mean, that's a day that might not have happened without the Charter in place, isn't it?
Absolutely. And you know, and I think this plays out in a lot of ways. Part of it is that, you know, the judges speak, it is now cast in stone and thus will be forevermore, perhaps. Other times, I think, as Peter's highlighting with that reminder about how the same-sex debate did end with legislation, it's more that it's a bit of a back and forth or an exchange or a conversation between legislatures and Parliament and the judiciary. The judiciary had been pointing the way with a whole host of earlier rulings that made it very clear what the rights framework around this issue had to be, and then Parliament finishes it off.
But I'm not sure allowing that kind of issue avoidance is healthy for our democracy. For us to allow politicians to punt to the court just seems to me to lower the expectations for them in dealing with rights. I want them to deal with rights seriously, and by saying, well, actually, you can go over to the other side and get a definitive ruling there. If we lower our expectations for politicians, I'm not sure we should be surprised that they would stoop to them.
We should never let the Charter somehow let our lawmakers off the hook.
But that's happening. But clearly that's happening.
Yeah, but we shouldn't. I mean, we need to, you know, that's what advocacy organizations do. We go back to those legislatures all the time to say, you shouldn't be waiting for the court ruling. You should get it right when you make the laws. That's when you need to think about rights compliance.
Well, and I do think this is an important point, that we certainly don't want the Charter to let parliamentarians off the hook. I think we can say 35 years on, though, that the Charter has had a very significant impact on how legislators legislate. And so the internal processes of government have changed quite significantly in response to the Charter. So no piece of legislation hits cabinet for approval before being introduced in the House now without some fairly rigorous charter vetting having occurred.
In other words, is this going to pass a charter challenge? They ask themselves that now.
Yeah, and so I think there's absolutely instances where legislation is tweaked before it's ever introduced because of charter concerns. And I think the important point here is that we have to be sure that governments are diligent about that. We want parliamentarians to be concerned about this as well. We can't just leave this all to the courts. There is some evidence, though, that these internal processes are continuing to evolve in ways that show concern for the Charter.
Peter Hogg, what do you call it? You said there's almost like a constant ongoing dialogue between legislatures and courts in this country in the post-charter world in which we now live.
Yes. Well, one thing that is interesting, Steve, is that after a charter decision striking down a law, normally what happens is Parliament or the legislature, whichever it is, finds a way to enact basically the same law but without violating the Charter of Rights. And so you have a long a study that I was involved in showed that out of 65 cases where laws were struck down, 2/3 of them the law had been reenacted, but in a form that was charter compliant. So it doesn't actually block democratic action. There's usually something that can be done without infringing on the Charter of Rights, which achieves the main legislative objective.
I know, Professor Baker, you won't be happy with the way I'm characterizing this, but let me try this anyway. We seem to be at a time in our history in Canada where the public generally feels more comfortable and appreciates the quote-unquote legitimacy of a Supreme Court decision more than they do the decisions of their politicians. And therefore, as Peter Hogg describes this dialogue that goes back and forth between the two, we seem to be okay with the way it is. Is that fair to say?
Yes, and I think that's sad, first of all, on behalf of our parliamentarians. But we might also say that just because the court gets it right most of the time doesn't mean they get it right all of the time. So what I'm always looking for in my research is opportunities for Parliament to respond, not just in the ways that Peter Hogg suggests, where there's a sequel that's charter compliant, but sometimes even legislation where the lawyers are telling them this is unconstitutional. So a clear example I can think of is when the court decided that because of the charter, extreme intoxication was a defense to sexual assault. That was a very controversial decision, had lots of public outcry against it. Parliament responded with legislation against some of their legal advisors saying, don't do this. They passed it, ordinary legislation, and then it was subsequently upheld in a series of cases.
Presumably, though, for this to work the way it does, judges have to be kind of in touch with contemporary society, prevailing mores, whatever the sort of, I don't want to say which way the wind's blowing, but you know what I'm saying? Are they?
Well, this is a tricky question. I think if you look at the composition of the Supreme Court, there are lots of scholars who do important work on diversity on the bench who would look at our current Supreme Court and raise some really important questions about whether this group of individuals truly represents the diversity of our country and is capable, whether these individual justices are capable of delivering justice. I think
just on that point, when you look at gender balance, we're doing a way lot better than the United States ever has, right?
Sure.
Well, we are.
Sure.
It's a fact.
Yeah, but I think that the moment you go beyond the Supreme Court, if you look at the statistics on gender diversity in the federally appointed judgeships, so this would be the superior courts in the provinces and the courts of appeal. Under the Harper government, the numbers were atrocious. You'll notice there's a number of women appointed recently, and I think in many ways that's an attempt to try to balance the numbers again a little bit. But there are still major diversity issues, both on along gender lines and along other lines as well.
And if you look at judicial analysis, legal analysis generally, including charter jurisprudence, it's filled with cultural assumptions, for example, that are unacknowledged as being specific to a culture. They're assumed to be universal. Even the objective standard, the reasonable person, it used to be the reasonable man, reasonable person, those are culturally based. You know, you go back to the Hegelian and individual rights. Even the Charter itself is an expression of cultural mores. So,
And I presume you're saying it's reflective of white person's culture as opposed to everybody's.
Yeah, non-Indigenous person's culture, the dominant culture in Canada, which to a certain extent is adopted and pervasive throughout diversity notwithstanding. It's imposed as the lens through which all legal analysis is really supposed to occur, and it's unacknowledged as a manifestation of culture. For us, for Indigenous people, our culture, our assumptions, our foundational assumptions about how people should relate to one another, what constitutes honorable, ethical, correct conduct, these are all different assumptions. And that has a very real implications, not only with respect to the criminal justice system, but our relationship with the state, our relationship, what governs even our commercial relations.
Well, I was going to say, it certainly goes deeper than this, but at the very surface level, it's, I guess, whether we relate more or care more about individual rights versus community rights. And I presume Indigenous and non-Indigenous have different views on this.
It's a fundamentally different worldview that has very concrete applications and manifestations in the daily lives of Indigenous people, whether we're in the city or within our own communities, and our ability to live as we have in our various cultures and in our various communities and territories and language is significantly infringed by this dominant legal lens, constitutional lens, which is assumed, because the people who sit on courts are people. They're individuals, they represent institutions, but they've been raised from birth within a culture.
Sure.
And they take for granted, naturally, and I'm not being critical, they take for granted what they believe in, the culture within which they've been raised. So the lack of diversity that we're talking about has real significant implications. It skews the jurisprudence towards inexorably and inevitably towards the dominant culture.
So what do we do about that?
Judicial appointments.
Indigenous judges.
Indigenous
On the
judges
Supreme Court.
and a broader range of not only racial diversity, socioeconomically, like, you know, if you have a lot of people who went through from relatively privileged positions through their education and their legal careers, they're going to have a fundamentally different interpretation about what's reasonable behavior and a different experience.
And I think to build on, I couldn't agree more about the imperative of addressing this concern about diversity. The sort of a companion piece, and maybe it's a bit of a remedial piece while we're waiting for that diversity to improve, is we need to make sure there are more richer, diverse perspectives in the court, especially when we are dealing with seminal charter cases. So it's making sure that there's a wide diversity of intervening organizations that are going to be bringing in that perspective. And the courts in Canada are very uneven. The Supreme Court is quite good. They're fairly liberal in welcoming in interveners to bring those other perspectives. Other levels of court tend to be very restrictive, and thus not only do you have the lack of diversity with the particular judge or judges, but they're not opening up the court process a bit more to bring in more of that diversity.
I saw Dennis smile. As soon as you said they're particularly liberal about something, and I assume you mean small L liberal, I saw Dennis rolling his eyes back there.
It was the equation of liberal and good that I rolled my eyes at. I always tell my students, when you're thinking about institutional rules, always imagine your opponents are the ones that are in charge of that institution. That just because you like the current composition, you don't want to make your institutional rules on that basis. It can be very dangerous, right? There will be different appointments, ones that you disagree with from people of different ideologies that might not see liberal as good, and that can be problematic. So I think
would
we
have
should
thought,
make
though,
rules on that.
we've had the longest-serving Chief Justice in Canadian history, Beverly McLaughlin from rural Alberta. I would have thought you would have kind of thought that was okay.
She's made good rulings and bad rulings, just as they've all made good rulings and bad.
Let me pick up on something Alex said a while ago, which was there was this program that we used to have whereby, what was it called again? The Court Challenges Program.
We had it, we didn't have it, we had it again, we didn't have it, now it's coming back.
Now it's coming back again. Do you think, how urgent do you think it is for us to have that in place to help those who don't necessarily have access to big money to make these challenges?
I've always thought it was a very strange program, Steve. Let's step back and marvel at what we're saying here. The government is going to subsidize groups to attack its own legislation. Well, if you're the government and you see defects and problems with your legislation, you have a much more direct way of addressing it. Repeal the law or amend the law. There's no reason to go through what we all concede is an onerous, burdensome, time-consuming process to do so. Moreover, the government has to pick winners and losers. So the liberal, leftist LEAF organization might get funded. The more conservative women's group, Real Women, is not going to get funded. But they both might equally want to challenge laws. You're going to pick winners and losers, which is why we don't see this program adopted in other liberal constitutional democracies.
Peter Hogg, what do you think of this program?
Well, I have some of the same reservations about the court challenges program. There is something weird about it. But when you take a case like the physician-assisted dying case, which was taken by Joe Ave, he had no funding whatsoever, and he assumed he had a huge number of plaintiffs, all of whom were, needed physician-assisted dying and weren't able to get it. And he had to sort of battle through the whole case without any resources at all. He incurred an enormous amount of debt. But when he finally won, the judge gave him a huge cost award and he was sort of protected. But had he lost, he would never have recovered that money. And it was a worthy case. So there's something to be said for making some money available for charter challenges, although I agree it is a little weird.
I think just to add to the Carter example, Joe had some beneficiary help from the fact that the BC Civil Liberties Association very much joined him in that case and brought...
Just say Carter is the doctor-assisted dying case.
Yes,
It's technically called the Carter case, right?
Brought their resources, lawyers, etc., to bear, which I think was in some respects, it was because they saw it too as an important human rights issue, wanted to take it up, but I think in some respects they were playing that court challenges program kind of role of making sure that this case could go forward. Yes. Well, we don't want to have an approach in Canada that leaves it ad hoc, that doesn't have some sort of clarity, an independent process that gives people access to justice.
Who makes the decision about whether an intervener gets court challenges funding? Is it the Minister of Justice's decision?
No, they have panels.
It's an independent panel.
Yeah.
Okay, so that should satisfy. You don't know how independent.
How independent is anything?
In fact, so with the most recent steps, they haven't enacted it in legislation. They've kept it within the executive, which I think that raises all sorts of antenna for me.
But if you as somebody who runs a law practice that's based on constitutional challenges and Indigenous child welfare and that sort of thing, I can tell you it is very, very difficult. And it has a fundamental impact on the cases that I'm able to bring. The access to justice issue is skewed. Government knows it, so they're less alive to it in terms of their policies and their legislating. And there's no democratic upside for any, because we are not part of the majority and many other marginalized and vulnerable people don't carry the big voting blocks. You need a means to challenge, to hold government to account, and that has to come with resources because we don't have them.
Understood.
And the one other thing to remember in terms of why the court challenges program is so important is that the other avenue that would open up access to justice is through the legal aid system, which is not federal, it's provincial, and it differs considerably across the province, including the levels of legal aid that are provided, who is or is not eligible, which areas of law will be covered, and so you've got that patchwork when it comes to legal aid, and the court challenges program is one way of ensuring that there'll be some consistency across the country.
We're down to about 5 minutes to go here. I want to see if I can get a couple more issues on the table. Peter Hogg, to you on this one. 5 years ago, 30th anniversary of the Charter, there were a couple of U.S. law professors at NYU who called Canada a constitutional trend setter. Do you think our Charter has acted as a model for other countries around the world?
It has acted as models for other countries around the world. It was very, very influential when South Africa achieved majority rule, and the Canadians went over and helped the South Africans frame their Charter of Rights. It's helped the Israelis the Canadians came to Israel and helped the Israelis to draft a Bill of Rights for Israel. So those were direct things, but it's also very it's got a good reputation, as it were, around the world, partly because Chief Justice Dixon was such a venerable character, and
He was the chief when Pierre Trudeau was prime
that's
minister.
right, yes, and he was so well respected, and the judges all talked to each other all across the world. I went to a conference and there was a room full of judges. They all knew each other. I didn't know any of them, but they all knew each other. They travel all the time. They talk to each other about their judgments, and so there's a lot of cross-fertilization going on, sort of behind the scenes.
I agree with Professor Hogg that it has been used as an example in those contexts, but in some of the discussions, say in our close constitutional cousins with New Zealand and Australia and the UK, sometimes the Charter is cited as a negative example. And when the UK went to move to the Human Rights Act, they were careful to make sure the new Supreme Court didn't have the power that the Canadian one does of striking down laws. It can merely declare them to be inconsistent, and then it leaves Parliament to remedy that. So sometimes it's an anti-example in some ways.
Professor McDonnell, as we look ahead then for the next 35 years, how do you see the Charter evolving over that period of time?
Well, in many ways, I think much depends on the political context. And when I look at where we stand with the Charter today, I think there's already quite a big difference under this government as opposed to under the previous government. To me, it's clear that a lot of rights protection ultimately depends on political will. It depends on what politicians do and whether they decide that they want to prioritize constitutional rights.
And whom they appoint to the bench too, I presume.
Absolutely. But as scholars have pointed out, most laws are never reviewed by courts. And so we have to be very attentive to laws when they're being proposed. And we really do place a lot of weight on parliamentarian shoulders. So I want to see a government that, as was said earlier, takes rights seriously. And I think that is really what will make a difference in terms of the potential strength of the Charter going forward.
Good. That's a good spot to leave it. I want to thank all of you for participating in our program as we look back and acknowledge the 35th anniversary of the Charter of Rights and Freedoms in the country, with an acknowledgement at the same time. Lots of work still to do. Thanks, everybody.
Thank you.
Thank you.
Help TVO create a better world through the power of learning. Visit TVO.org and make a tax-deductible donation today.